Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, a couple of weeks ago during our live chat, a lot of you had questions about the challenge to California's magazine ban, a case called Duncan v. Bonta, and how that might affect us here. Well, there has been some updates, and so I think it's important that we share some of those with you. So today, we're going to spend a few minutes and talk about what is happening with Duncan v. Bonta and high-capacity magazine bans. Okay, before we get going down the road that we are going down today, proud to announce that this video is being brought to you by Security Gun Club in Woodinville, Washington. That's right, Security Gun Club, the nicest indoor range you will find anywhere in the state of Washington. The facility is absolutely amazing. The only two things better than the facility: number one, they got the best and friendliest staff in the business. Stop by, say hi, tell them I sent you. The thing that impresses me the most about security, however, is their dedication to education. You see, Jackson, the head of training over there, former law enforcement officer himself, has developed an amazing curriculum that will cater to anybody of any skill level. Are you brand new to firearms? They got classes for you. Have you been around firearms your entire life? Trust me, they got classes for you. Are you a female who's always looking for a more approachable way to learn about firearms? Well, then sign up for their women's only classes. Visit them at securitygunclub.com. Now, that is not a misprint. That is security with an E. And hey, if you find a class over there you like, go ahead and use promo code WAGUNLAW. That is promo code WAGUNLAW, all one word, and you will receive 10% off your first class. For more information, visit them at securitygunclub.com. Okay, so the issue I'm talking about today is not the first or the second time that we've talked about it. It's a case called Duncan v. Bonta. Now, Duncan v. Bonta is a challenge to California's magazine ban. California has a ban, as do a few other states, that limits capacity of magazines to no more than 10 rounds. Sound familiar? Now, when we go back and we got to kind of trace the historical background of this case, because you're going to see where this thing is getting teed up and you're going to see what the Ninth Circuit is. So, quick little history lesson about what happened here, okay? So, Duncan sues Becerra, who at the time was the California Attorney General, and the case is filed in the Southern District of California in San Diego. The case is heard before Judge Benitez. What Duncan is asking for is an injunction, an order of the court stopping the implementation and enforcement of California's high-capacity magazine ban because it violates Duncan's Second Amendment rights. The Honorable Judge Benitez in the U.S. District Court for San Diego issued that injunction. And interestingly, what Judge Benitez did is he applied a very strict scrutiny analysis. Does that sound familiar? Yeah, it is literally, he was like Nostradamus, okay? He authored an opinion that some people might think was actually authored by Justice Clarence Thomas because he really understood the rich text and history tradition of the Second Amendment and did not go outside the purview of that in striking down California's magazine ban. Now, the state of California, of course, completely crapped themselves over this, and so they appealed to the Ninth Circuit. Now, when cases are originally appealed to the Ninth Circuit Court, oftentimes they are assigned only a 3-judge panel. 3 judges were impaneled by that, and Duncan wins again at the appellate level. In a 2-to-1 decision, the court upholds the injunction. Now, interestingly, that 3-judge panel applied an intermediate scrutiny analysis. So they did this little 2-part test that we've been talking about for the last few weeks that's kind of a no-no. But somehow, even though they applied the wrong standard, they came to the correct conclusion. However, state of California got all ticked off about that, so then they appealed to the en banc, the full panel of the Ninth Circuit, and when they accepted review, we all kind of knew that the fix was in. What happened at the Ninth Circuit level? Well, the court applied that 2-part analysis and said, listen, even though this may infringe upon Duncan's Second Amendment rights, the need to society, the need to protect people from these weapons of war, is so great that the interest outweighed the infringement to Duncan, and so therefore reinstated California's high-capacity magazine ban. Now, Duncan, on the other hand, now decides he needs to appeal this to the United States Supreme Court, so up they go. Now, when you apply to go to the United States Supreme Court, it's called a petition for certiorari. It's a fancy name for it's an application. and the court gets to decide whether or not they will accept your review. In most cases, actually are not accepted. And had that occurred in Duncan v. Bonta, the holdings in the Ninth Circuit would have been the law of the land in the Ninth Circuit as it relates to that. Washington, of course, being in the Ninth Circuit. However, after the rulings of New York Pistol and Rifle Association v. Bruen came down, the United States Supreme Court GVR'd Duncan v. Bonta, which means they granted review, good news, they vacated the ruling of the lower court, extra good news, and they remanded the case back down to the Ninth Circuit for holdings consistent with the rules announced in Bruen. Basically, it's the Supreme Court's way of saying, hey, you got it wrong. Here's a roadmap on how to do it right. You get a do-over, go fix it. Okay, and that's essentially what's happened here. Now, what has happened since the case got back down to the Ninth Circuit? Because we covered the GVR in this video right here. So what's happened? Well, the Ninth Circuit now has vacated the ruling and has remanded the case back down to the trial level, which means this case is going back down to the United States District Court in San Diego and going to be reheard by Judge Benitez, who properly applied the correct legal standard the first time and got the right conclusion. So why is the Ninth Circuit sending it all the way back down to the trial court? Well, I think it's a delay tactic. I think they know that if they send it back down to the trial court, it's going to ricochet down there for a while. The courts are incredibly burdened and completely overrun right now, especially coming out of the pandemic. And the likelihood that this case could be resolved before the end of the calendar year is greatly lessened by the Ninth Circuit kicking this thing all the way back. The Ninth Circuit is ticked off here. Their ruling has been overturned, and they have an extreme political agenda here that they are trying to advance. They need to stall this in any way humanly possible, and that is the reason why I believe they are sending it back to the district court in San Diego. But when Judge Benitez hears this, even though he applied the correct standard and came to the correct conclusion, I think we all know where Judge Benitez is going with this. Will the state of California yet again appeal? They will, but the problem is the legal framework by which they can argue has been significantly and forever changed by the holdings of Bruen. Therefore, it is entirely possible that we will see a ruling from Judge Benitez sometime this calendar year, which again enjoins the state of California from enforcing their magazine ban, basically finds it to be unconstitutional. The state of California will cry, as they usually do, and may attempt to appeal it, but that is where they are likely to run into a dead end, because they're going to have to admit now that the rule of law, the rule that applies in this case, is the ruling that's held under Bruen, which is that we are only going to take a look at that one-part analysis. So in reality, could magazine bans be coming to an end? Yes, they could. If any of these circuit courts apply the correct legal standard, there is one and only one conclusion that they can come to, which is there is no history or tradition of magazine bans. It clearly infringes upon a person's Second Amendment rights, and in many instances, these magazines are used in firearms which are in common use today for things such as self-defense. Listen, you may have more questions about this magazine ban, Duncan v. Bonta, or anything else that's going on with your Second Amendment rights. And if you do, don't ever hesitate to contact us at WashingtonGunLaw.com. Or, of course, you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.